Okay, I've got that. We're right at 3 o'clock. Welcome and thank you for joining us today for our IRA Planning Secured, Revisiting the Secure Act after an Eventful 2020 webinar. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith. Before we begin, I do have a few housekeeping items. We are going to utilize a few PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both our videos and the slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose the side-by-side mode. The slide deck should appear on the left and our videos should appear on the right. You can then slide the separator to the left or right to adjust the size of each view. If you have any issues with the video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Today's presenters are John Sella and Tom Zimatics. John counsels clients in estate and business planning matters. He prepares estate planning documents, including wills, revocable trusts, minors trust, irrevocable life insurance trusts, and charitable trusts, and advises clients on the income, estate, gift, and generation skipping transfer tax consequences of wealth transfers to individuals, trusts, and charitable organizations. His background in employee benefits and compensation is beneficial to clients considering income and estate tax aspects of distributions, rollovers, and trustee-to-trustee transfers from qualified retirement plans and/or IRAs. Tom works closely with individuals, families, and closely held business owners to provide personalized goals to help identify and achieve their unique estate planning goals. His practice focuses on estate planning and estate and trust administration. He assists clients in the preparation of a wide range of estate planning documents, including wills, trusts, and powers of attorney. I'll turn the mic over to Tom and we'll begin.
Thank you, Jen. Good afternoon, everyone. Thank you for joining us today. As Jen said, my name is Tom Zimatics. I'm an attorney here in our Raleigh office, and I focus my practice on trusts and estates. The goal of our presentation today is to review IRA plans in the context of estate planning generally, as well as to revisit the Secure Act after what can be described as an eventful 2020. I know that many of you on the call today have kept up with the Secure Act since its inception in late 2019, and some of you have turned your attention over the course of 2020 to other COVID legislation, as well as other events. And so we think early 2021 is a great time to revisit how the Secure Act may impact IRA planning in the context of an estate plan. And so with that, I'll turn to the first slide. And I will preach to the choir here a little bit and tell you why IRA planning matters. Whether you are an IRA owner or a financial advisor, you probably already know that IRA planning matters, but from what we have seen, retirement accounts generally have only increased as a proportion of individuals and families' net worth. And so in the estate plan context, what that means is that retirement accounts are increasingly becoming a vehicle to transfer wealth from one generation to the other. And so not that it has ever been, but IRA planning certainly cannot be an afterthought when it comes to an estate plan. And whether you've made this comment recently yourself, or you've heard someone say it themselves that they need to update their will and that it's been some time, in conjunction with that statement should always be, and I should update my beneficiary designations and check in on my retirement accounts. And so we'll talk about that today. In terms of the outline for the presentation today, I'll be talking about some introductory material as well as introducing the Secure Act before turning it over to John to run through some common scenarios that we see not only in the IRA planning context, but also the impact of the Secure Act. And so the next slide we want to talk about estate planning for retirement assets and what that means. So I think before you even get to step one in thinking about how to implement your retirement plan into your estate plan, what I would say is step zero is understanding beneficiary designations and what those mean. I know that many of you on the call today are familiar with the concept, but for anyone who is not, when we talk about implementing an IRA into an estate plan, the step in order to make that happen, the initial step or the key step, is to do that through your beneficiary designation under the plan. Put another way, an IRA owner will designate a beneficiary who will receive the assets upon the owner's death. In contrast, a will would dictate how the IRA owner's individually owned assets that are separate from the IRA would pass to beneficiaries. And so it's important when you think through your retirement plan, not only to think about how it affects you during your retirement, but to make sure that your beneficiary designations are updated appropriately. And so that's step zero. And in terms of steps 1, 2, 3, those things, I can kind of split it up into 2 buckets, right? So there's non-tax considerations and tax considerations. Some of the non-tax considerations include the identity of beneficiaries, control, creditor protection. And just like in a traditional estate plan, an IRA owner will have to decide not only to whom the assets should pass at his or her death, but also how. And that's where today we'll talk about certain trusts that could be established to receive the IRA assets and how the Secure Act may impact plans that are currently in place, trust-based plans that are currently in place. In terms of transfer tax, a retirement account will be includable in the IRA owner's gross estate. It's something to look out for. Currently, the estate tax exemption in 2021 is $11.7 million per individual. That's due to sunset to $5 million index for inflation by 2026. And with the makeup in Congress, it could happen sooner. So it's something to consider. And that's important too in understanding the overall makeup of an individual's assets and whether or not their retirement account will be used to pay estate taxes, or how the beneficiaries could be impacted if they receive a retirement account and the estate owes estate tax. Obviously, with retirement accounts, income tax considerations are always top of mind for an IRA owner. But much of what we talk about today will also be about the income tax considerations for the beneficiaries. And that's one of the main effects of the Secure Act and how planning may change. So Jen, please go to the next slide. Okay, so on this slide, we have information that an IRA owner, as well as the attorney or financial advisor, should gather at the outset of IRA planning in the context of an estate plan. And I think really the key point I want to get across with this slide is that I think there's no better illustration of the benefits to a team approach across professional services than retirement planning, and specifically the impact of the Secure Act. It's not enough for an estate planning attorney to understand how an individual may want to pass his or her assets at death without also understanding, especially when a retirement account makes up a big portion of their overall net worth, understanding how that retirement account plays into their wealth as they are in retirement, as well as understanding the income tax issues that are present during retirement and present for the beneficiaries at the owner's death. So, whether you're on the financial advising side, the legal side, or the CPA, or if you're the IRA owner, anytime you're planning with your IRA, especially using it as a vehicle to transfer wealth from one generation to the other, we recommend a team approach and collaboration among the advisors. Next slide, please. And just want to raise again the impact of the Secure Act on IRA planning and the income tax considerations. I know that there's COVID legislation this past year that did away with some of the traditional penalties. But I think this slide gets to why the team approach is so important for someone who's using their retirement account, say when they're in their 50s to 60s, all the way through all of their retirement, and then also want to leave it for their children or surviving spouse. There's a lot of different phases where the income tax rules will come into play, and specifically with required beginning dates and required minimum distributions, which we will talk about here shortly. So next, I would like to introduce the Secure Act, or reintroduce the Secure Act. It was introduced back in late 2019, and it's brought many changes overall to the Internal Revenue Code and the rules pertaining to retirement accounts. From our perspective as estate planners, there's a few changes that are most notable. Number one is that the required beginning date for required minimum distributions is now the year after the owner, the year in which the owner turns 72. And so that's an increase in age from 70 and a half to 72. And I think that's another piece of the legislation that will ultimately, again, increase the prevalence of retirement accounts making up a large portion of individuals' net worth, and contribute to the fact that those accounts will also be used to transfer wealth to the next generation. Another notable change that the Secure Act brings is that for traditional IRAs, there is no longer an age cap on contributions. We'll get to some of the specific rules here in a minute. There are deduction rules that you have to keep in mind if you plan to continue to fund your retirement account or your traditional IRA through your 70s. But overall, there's no longer an age cap in making contributions. And a third notable change that the Secure Act has brought to the code as it pertains to retirement accounts is really the one that when you hear about how the Secure Act changes IRA plans in the context of an estate plan, this is the change we're talking about. The elimination of the stretch life expectancy payout for certain beneficiaries. Okay, so we're going to be using terms in the presentation such as designated beneficiary, eligible designated beneficiary, the stretch life expectancy payout, and the 10-year rule. And that's really the crux of the different strategies that John is going to be talking about here in a minute, is how do we account now for a change in the rules. And so before the Secure Act, individuals who are named as beneficiaries of a retirement account could stretch the required minimum distributions across a life expectancy payout, and we'll illustrate that in a minute. Now there are only eligible designated beneficiaries who get that benefit, who can continue to stretch out the retirement account throughout their life expectancy. For all other individuals, they will have to deplete the account within 10 years of the owner's death. And so when there's an IRA owner who's made plans with their retirement account within their estate plan to provide for their children, for example, that includes asset control, protection, trusts, income tax considerations, and thoughtful planning that was maybe implemented just a few years ago, those plans will likely need to be updated in light of the Secure Act. So here's an illustration of, or one illustration of potential impact from the Secure Act. So on the left side of the screen is an example of how it used to work before the Secure Act. So imagine a mother who's age 67, she passes away in November of 2019. She has a daughter, Grace, who's age 40, and the mother leaves her IRA for Grace. And going back to step 0, how does she do that? She designated Grace as her beneficiary under the account. And so Grace has an IRA or she inherits an IRA from her mother. What Grace would then do is she would establish an inherited IRA. Again, she's the designated beneficiary under the previous rules. And I think this here illustrates the benefit of the life expectancy payout, where in year 2020, Grace would determine her life expectancy given her current age, combine that with the balance of the retirement account, and determine her required minimum distribution, which is about $23,000 in that first year. Grace would then do that year in and year out over the course of her life expectancy. And as you can see, there would be decades of income tax deferral. This is why before the Secure Act, retirement accounts were a great vehicle to pass wealth to the next generation and provide funds for children with some pretty nice features in terms of income tax. Just a quick change of the illustration, the mother could have left the IRA to Grace in trust and have it qualify as a see-through trust, which I'll get to in a minute. And again, that would still allow for that life expectancy payout with some asset protection in there. Now turning to the right side of the screen and the impact of the Secure Act, we have generally the same facts. We have a mother who has a substantial IRA and she passes away and she names her daughter Grace as the beneficiary. Under the Secure Act, Grace does not qualify as an eligible designated beneficiary, an EDB. She does not qualify because she's not one of the named or the types of people named in the Secure Act who qualify as an eligible designated beneficiary. As an adult child, she's not one of them. And so instead of getting to take advantage of the life expectancy payout, now Grace receives the retirement account and she has to deplete it within 10 years, the 10th anniversary of her mother's death. There is not a requirement that Grace has to take out 1/10 each year, but the requirement is that the retirement account must be depleted and withdrawn to Grace within 10 years. Obviously, Grace now has potentially an income tax issue that she otherwise would not have had. And going back to changing up the illustration a little bit, if let's say the mother was concerned about Grace's ability to manage the accounts or the assets, and she was concerned that maybe Grace on her own accord would not take advantage of the life expectancy payout, she may have qualified a trust to benefit Grace with the retirement account. Well, now some of those provisions that were previously drafted to account for the life expectancy payout will have to be changed, right? That there's now a 10-year rule. There's no required minimum distribution per year. And so those are some of the scenarios that we'll talk about here in a moment. So the next slide, just going back to the required beginning date, I think it's important for everyone to think through it. And the reason we highlight the increase in the age from 70 and a half to 72, at least in the case of traditional IRAs, and the same rule applies for 5% owners of a company under a qualified retirement plan. I think it's just a good reminder within the Secure Act of the idea that these IRAs will be used to transfer wealth from one generation to the next. And that for many people, they'll delay taking from their retirement account. And as retirement accounts continue to be a greater portion of each individual's own financial assets, the planning not only for retirement, but after death becomes more important. And so the next slide wants to revisit the required minimum distribution. So I know most of you are familiar with the required minimum distribution. It was illustrated in our previous example where you would take life expectancy in the case of Grace before the Secure Act, and it calculates the amount that either the IRA owner or beneficiary must take from their retirement account each year. And so the age 72 is the year after the owner reaches age 72 is when those required minimum distributions begin. And so that's why age 72 is an important age to keep in mind. The next slide. So I said a few slides ago that the most notable change in the estate planning context to keep in mind both during the presentation and afterwards is the life expectancy payout versus the 10-year rule. This slide illustrates the difference in who qualifies for either the life expectancy payout or the 10-year rule. So on the left side again of your screen, that was the previous rule, that there was designated beneficiaries. Any named individual would get to take advantage of the life expectancy payout, or you could qualify a trust that would be considered a see-through trust and again be able to take advantage of the life expectancy payout. The most important thing about Secure Act, or one of the most important things about the Secure Act, is this new term, the eligible designated beneficiary. And as you can see, the 5 types of individuals listed in red on the right are those who are able to still take advantage of the life expectancy payout. A spouse, a child who has not reached the age of majority. We're still waiting on Treasury guidance with some of the terms of reaching majority and still being in school. But the rule to keep in mind is a child who has not reached majority, a disabled individual, chronically ill individuals, and an individual not more than 10 years younger than the owner. And I'll just add here, if you think back to the example of Grace and her mother, you know, if the mother does not have a surviving spouse, Grace is her only child, and all she wants to do is leave her assets to Grace outright. Well, you can see that the Secure Act does have an effect on that plan, right? Grace cannot take advantage of the life expectancy payout because she's not one of those, she does not fall under one of those 5 types of individuals. But I think another illustration would show the impact of the Secure Act even more. Let's say that Grace had a taxable estate, or excuse me, Grace's mother had a taxable estate. She had siblings who she wanted to provide for. She had charitable goals that she wanted to accomplish. Well, now that's where the decisions of who gets the IRA and how become much more important. For example, if Grace's mother had a sibling who was just a few years younger than her and she wanted to provide for that sibling, well, given the Secure Act, it may make sense to name the sibling as the beneficiary because the sibling would qualify as an eligible designated beneficiary. And overall, the assets in the account would be optimally provided to the sibling as opposed to Grace, who has income tax issue. Obviously, you know, that could depend on the given situation, but I think the more complicated, or the more that the IRA owner wants to consider the estate plan and how he or she can provide for multiple individuals, the more important the Secure Act becomes. And so one more slide for me before I hand it over to John is just the concept of the see-through trust. And so these concepts remain the same, more or less after the Secure Act, but how they are actually implemented and administered can change after the Secure Act. And it's just an important concept to keep in mind as we go through some of the common scenarios here in a moment. So using the same example of Grace and her mother, right? Before, Grace would qualify as a designated beneficiary and have the life expectancy payout because she was an individual. You can qualify a trust to qualify now as an eligible designated beneficiary. And again, you can have the life expectancy payout and have the beneficiary of the IRA receive the assets in trust so that you still have asset protection and you take advantage of the life expectancy payout. And so just a couple terms to keep in mind: the Conduit Trust, which requires payment from the IRA to the trust beneficiary, or the Accumulation Trust, which, as the name implies, accumulates the distributions in the trust. We'll ultimately have to decide for conduit trusts whether or not they're still effective. They're certainly problematic given the Secure Act and the 10-year rule. Accumulation trusts may still be functional, but the income tax hit, given the tax rates at the trust level, could be high as well. So with that, those were some of the introductory topics for the webinar, and I'll pass it over to John Sella, who's going to talk about some of the common scenarios and strategies that we use in light of the Secure Act.
Great. Thank you, Tom. That was terrific. And Jen, thank you as well. And to everyone who's participating this afternoon, thank you for your time. Let's go ahead and dive in with the spouse outright. Next slide. Okay. Hal died at age 68, i.e. he died before his required beginning date. His spouse, Wendy, age 65, is the beneficiary. Wendy, as a surviving spouse, qualifies as an eligible designated beneficiary, and thus she can receive the life expectancy payout. No change from prior law. In addition, as you know, Wendy can roll over Hal's IRA into Wendy's own IRA and wait until her required beginning date, April 1 of the year following the year she reaches age 72, to take distributions. Again, that's optimal income tax deferral. Now, one thing to keep in mind, if Wendy were a younger surviving spouse and if Wendy needed the funds sooner, the code offers the option of a spousal inherited IRA so that Wendy could create an inherited IRA and use her life expectancy to receive distributions beginning no later than 12/31 of the year following the year of Hal's death. And in that, a spousal inherited IRA for that type of client may be preferable, so you don't run into a situation where Wendy, if Wendy had to take funds out of a spousal rollover IRA and pay a 10% premature withdrawal penalty. Now, the change in the Secure Act, let's go back to the prior slide, excuse me. I want to point out the big change is what happens if Wendy names her adult child as beneficiary. Under the old rules, as Tom explained in the Grace example, the adult child could use his or her own life expectancy for the payout from an inherited IRA. Given that Wendy created a spousal rollover IRA, and furthermore that Wendy named her adult child as beneficiary, we're stuck with a 10-year rule, meaning that the adult child, and again, we're assuming the adult child is not disabled or chronically ill, the adult child must deplete that entire inherited IRA no later than 12/31 of the year that contains the 10th anniversary of Wendy's death. That's a big hit income tax wise. And again, as Tom said, these are not annual required distributions from an inherited IRA under the 10-year rule. Rather, the beneficiary would strategize with his or her investment advisor and CPA to see, identify the years in which she should take more out and be taxed on distributions from that inherited IRA. So the rules are largely the same, other than the successor beneficiary treatment. Next, let's go to the death after required beginning date. Hal died at 75. He didn't take his required distribution before he died. So that's an important point. Remember that the Hal's 2021 RMD is paid to Wendy as beneficiary. And then Wendy can take required minimum distributions using the longer of what we call, what most people call the ghost life expectancy, or Wendy's remaining life expectancy, and she would have to begin taking distributions no later than the end of the year following the year of death. So again, the rules for spouses outright are largely the same, other than the successor beneficiary treatment. Next slide. Thank you. Okay, the person who's no more than 10 years younger, and again, we think of clients, you want to think about the types of clients who fit in this category. That would be, unmarried individuals who, for example, may leave the IRA to a sibling, or unmarried couples who are close in age. So in this example, Hal died at age 68. He names his brother Ben as beneficiary of his IRA. Ben, because Ben is no more than 10 years younger, qualifies as an eligible designated beneficiary. And upon Ben's death, though, again, the successor beneficiary treatment is key. If Ben's daughter is the beneficiary of the inherited IRA, then Ben's daughter is stuck with the 10-year rule, where under prior law, Ben's daughter would take the remaining distributions determined based on Ben's life expectancy. So again, under the Secure Act, Ben is an eligible designated beneficiary. The inherited IRA beneficiary, Sue, is stuck with the 10-year rule. Next one. Next slide. Thank you. Okay. Let's talk about minor children. I have the exclamation point there. I think those of you who are listening would probably agree with me. It astounds me how many really sophisticated clients, believe that they could name a minor child outright as a contingent beneficiary. It does happen, and it's not an unmanageable situation in the wake of a tragedy. But again, the goal is not to name a minor outright as beneficiary of a retirement account. Here's why. So let's look at Jill. Named her husband Jack as primary, and she named her 7-year-old son Mac as the contingent beneficiary. Jack and Jill died. So Mac is beneficiary of Jill's IRA. So as a minor child, and again, the word is child, grandchildren, nieces, nephews, etc., they don't qualify as eligible designated beneficiaries, just children. So minor children. So Mac is an eligible designated beneficiary. He qualifies for the life expectancy payout. Here's the mess that occurs in the wake of this tragedy. Mac does not have legal capacity to own an IRA, and so a court has to appoint a guardian of the estate, meaning guardian of the money, of the financial assets, as opposed to guardian of your person. The court has to appoint a guardian of the estate to hold the inherited IRA for Mac's benefit. Now, I mean, practically speaking, within families, let's think about Jill's parents and Jack's parents, having lost their adult children, and just think about the dynamics of, determining who's going to be the guardian to hold that inherited IRA for Mac's benefit. It's complicated, it's expensive, and there are ways to avoid that in the estate planning process. Now, after secure, the guardian of the estate takes the required minimum distributions based on Mac's life expectancy, meaning many, many years, and small payments, beginning no later than 12/31 of the year following the year of Jill's death. But here's the problem. And we're going to assume that the Treasury is going to clarify the age of majority for purposes of the Secure Act, but for our purposes, let's assume 18. That's what it is in North Carolina. So the guardian of the estate must transfer the inherited IRA to Mac upon his attainment of age 18. And you can only imagine what that situation would be if Mac is a spendthrift and reckless. The money will be taxed, and then gone. If Mac is prudent, he would keep the inherited IRA, and the distributions would be subject to the 10-year rule. So he would have to deplete that IRA no later than the end of that 10th year after he reaches majority. I'm not sure how many 18-year-olds would keep monies in an inherited IRA for 10 years, but I'm hopeful we'll have people who do that. Next slide. Thank you. Okay, the Conduit Trust for the benefit of the minor child. Before Secure, sometimes you would see Testamentary Trust created for a minor child, and the Conduit Trust provisions would allow the trustee to make distributions based on the minor child's very long life expectancy, and thus push the required minimum distributions from the IRA to the trustee and then immediately out to the beneficiary. Well, practically speaking, those payments were rather small. And so over a lifetime, I mean, you would be in a position to optimize your income tax deferral and still enjoy the creditor protection of having the IRA and trust. Well, after the Secure Act, a conduit trust could have disastrous consequences, meaning max life expectancy would be used until majority, but upon max majority, the 10-year rule would apply, and every distribution that comes from the IRA to the trustee must be immediately distributed to the beneficiary based on that conduit language in the trust. So that's a disaster, because at the end of the day, Mac could have a 6 or 7 digit IRA fully distributed to him before he's 28. And so you would lose the income tax deferral and you lose the creditor protection there. So thus, one of our messages today is to review trust documents very carefully for conduit trust language. Okay, so as I said, this is sort of a disastrous combination. Outdated conduit trust provisions plus the Secure Act's 10-year rule. That's what you want to focus on. Does my trust document contain conduit trust provisions? And what would happen? Run the death scenarios with respect to that trust document and the current 10-year rule that we have under the Secure Act. Okay, so let's recap. So for a minor child, we've talked about outright, we've talked about the problems with the conduit trust. Let's move to options 3 and 4 on the next slide and focus on those. So as part of this qualified retirement plan and IRA review, again, you'll want to check your trust documents. If your trust documents have conduit provisions, those need to be revised, eliminated, and those provisions should be amended. One option would be the see-through accumulation trust. As Tom pointed out, we have the regulatory prongs for see-through trust status. Then the question is, how do you design the trust as an accumulation trust? And generally speaking, an accumulation trust has all human being beneficiaries, with the exception, of mere potential successors. And again, that's just based on what we have been able to gather from the IRS. We may have more guidance soon. So if a trust for the benefit of minor children is restated and has the appropriate provisions, then we should be able to take advantage of that 10-year rule. But more important, we would be able to accumulate those distributions within the trust. Again, remember the accumulation trust. The money flows from the IRA to the trust and it remains in the trust, or the trustee consults with his, her, or its investment advisor and CPA to determine how much money and which portion, the amount to flow out to a trust beneficiary, and then the amount to accumulate within the trust. Now, we are expecting some Treasury guidance on whether an accumulation trust for the benefit of an eligible designated beneficiary, whether we could get life expectancy payout treatment for that. Those rules are pending. Okay, let's talk about non-disabled or chronically ill adult children briefly. You know, this is this is a little more complicated in some ways, and again, it's very facts and circumstances. You know, it's determined by the facts and circumstances. So, big picture. Let's say mom is a surviving spouse, and mom leaves her IRA to 3 adult children outright. That means non-disabled, non-chronically ill adult child has the ability to create an inherited IRA, but will not be able to take advantage of the life expectancy payout because that adult child doesn't qualify as an eligible designated beneficiary. Now, so we're stuck with these inherited IRAs and the 10-year rule. Now, under North Carolina law, we do have creditor protection for inherited IRAs, but again, the protection's there only if the child doesn't take the money out of the IRA, okay? So that's something that clients really need to, you know, think through, is the extent to which they have confidence in their adult children's ability to handle IRA distributions to them. And again, what do you have to think about? You know, children who do not manage money as well, certainly in-law issues. If your child has a spouse and you may have great affection for that spouse, but you may have concerns about that spouse's family, et cetera. And then of course your typical creditor protection concerns relating to tort and contract judgment creditors. So outright to the adult child, we're left with the 10-year rule. We would not want a see-through conduit trust for an adult child, and we understand why. And then 3, the see-through accumulation trust for the adult child also may be a viable option. Again, if the trust is designed properly, and these documents that are old and cold are likely not designed properly, a see-through accumulation trust for the benefit of an adult child, you know, is intended to qualify for the 10-year rule and to give the trustee the ability to accumulate the required minimum distributions and decide on the amounts to be distributed outright to the adult child and the amounts to be accumulated within the trust. And again, I'm gonna say it till I'm blue in the face. You've got, the client must consult with the investment advisor and the CPA when we're dealing with trust-owned IRA distributions. Okay, the Secure Act had some favorable provisions for disabled or chronically ill beneficiaries. The status is the status as of the owner's death. We have a number of clients, you know, with adult children who may have a physical or mental impairment, and part of how we serve those clients is we want to make sure that any supplemental or special needs trust is designed properly to take advantage of the life expectancy payout that is available to disabled or chronically ill individuals on account of the Secure Act eligible designated beneficiary status. So let's move to the next one. Thank you. Okay, so in the special needs world, big picture, We have first-party special needs, self-settled trusts, personal injury settlement, or an inheritance that somehow ended up flowing to an individual with special needs. So that's when the special needs individual creates a trust to hold those assets. And then third-party special needs trust, which we see so often with our clients, is mom and dad or a parent creates a trust for the benefit of that disabled or chronically ill child. Okay, next slide. Thank you. So the Secure Act gave us a new term. We call it an AMBIT, an applicable multi-beneficiary trust. And it enables trust planning for beneficiaries who are disabled or chronically ill. But here's the catch. In the Type 1 AMBIT, the trust must provide that the disabled chronically ill beneficiary is the sole lifetime beneficiary of that trust, the sole current beneficiary of that trust. And then when the trust divides, excuse me, I think that was Type 2 I was talking about. Type 1 is the one where the owner divides the trust. So mom's revocable trust splits into several subtrusts, and one subtrust is for the benefit of a disabled or chronically ill child. The Secure rule says that the life expectancy payout applies separately to that subtrust for the disabled or chronically ill beneficiary. And that's a change from the old rule that required the use of the oldest trust beneficiary's life expectancy, regardless of the split. And there were lots of letter rulings on that point. But bottom line is, in the special needs world, you want to look at the special needs beneficiary and the trust provisions that provide for that beneficiary currently, and no one else. If anyone else is able to share, then you're not going to get the life expectancy payout. We are expecting more guidance on AMBITs, and should be able to assist clients more effectively once we have that guidance. But again, all special needs trusts, whether they're freestanding or embedded within a revocable trust, need to be reviewed very carefully in the wake of Secure. Okay, for a surviving spouse. We've talked about outright to a surviving spouse. The rules are largely the same post-Secure, other than the successor beneficiary treatment. The see-through conduit trust for the benefit of the surviving spouse, we may see that with a Q-tip conduit marital trust. We had some Treasury guidance back in 2006 that gave us the magic language to qualify for the marital deduction, meaning the trust would have to distribute the greater of the required minimum distribution or trust accounting income to the surviving spouse. Now, at this point, the only way for a marital trust at this point to qualify for the life expectancy payout is for it to be a conduit marital trust, meaning the distributions flow to the trustee, and the trustee must immediately pay those monies out to the surviving spouse. And again, focus on successor beneficiary treatment upon the surviving spouse's death. The 10-year rule applies. Now, just to keep in mind, remember all the spousal consent rules. Federal law requires your spouse to be primary beneficiary of your qualified retirement plan, governed by ERISA. If you choose to name someone other than your spouse, you must follow the qualified retirement plan procedures to have the spouse formally consent to the naming of a non-spouse beneficiary. Next slide. Okay, let's talk about the see-through accumulation trust for the benefit of the surviving spouse. I think this one is this is a good tool in the toolbox for the second marriage because the creator of the trust can design the trust as an accumulation trust, a see-through accumulation trust, where the IRA distributes to the trust and then can accumulate those distributions within the trust and or pay monies from the trust to the spouse pursuant to trust terms. So it gives the creator of the trust a bit more control. It's not as ideal from an income tax standpoint, but at the end of the day, it may be a good option in the second marriage situation where a client may want to preserve those trust assets for children of a prior marriage after the death of the surviving spouse. Another possibility in second marriage situations, really just to go the simple route, is engage with advisors to very carefully evaluate the types of property and run the numbers. And it may be beneficial to simply leave a portion outright to a surviving spouse and a portion outright to children of the prior marriage. And of course, in any second marriage situation, you'll want to you'll want to rope in the family lawyer and see what any premarital or post-marital agreement says with respect to retirement benefits. Okay, let's talk about some strategies briefly. Okay, the Roth IRA is truly one of the best tools in the toolbox with our tax code. I mean, I'm surprised it hasn't been eliminated by now. We've had it for many years, and it's a nice tool for teenagers with earned income, for example. But at the end of the day, the Roth conversion enables a client to diversify his or her income tax exposure. So, again, in consultation with advisors, a client may want to convert some retirement monies and leave the other assets alone. This is really important today, just for a number of reasons, but it's not necessarily the thing to do. And here's why. We have to look at all the factors, and again, consultation with investment advisors and CPAs is mandatory in the Roth conversion context. What do we have to think about? Well, first, you want to look at qualified plan Roth accounts and see if there are any opportunities to convert strategically any tax deferred monies to Roth accounts. Remember, no one can convert an inherited IRA unless you're a surviving spouse, but you have to remember the surviving spouse actually has to treat the retirement account as his or her own retirement account in order to do that. What are some of the considerations? I mean, obviously the holding periods and the expected current expected income tax rates, your current and prior year carryovers and losses. I think in today's environment, I mean, I'm not sure how long all this can go on, but current and expected investment values, I think, are particularly important today. And then, for years, if you're going to do a Roth conversion, you want to make sure you have funds outside the IRA to pay the federal and North Carolina income taxes that are due. And again, you have to run these numbers with your CPA and investment advisor. Okay, let's talk about charitable planning for a minute. And the slide says CRTs, but before I get into that, let's look at the big picture here. If you have a client with a taxable estate for federal estate tax purposes, and the client doesn't need the IRA, then it's a home run to consider using that IRA for charitable planning. So, a client may want to leave the IRA to a public charity, a private non-operating family foundation, a donor advised fund. I mean, there are lots of ways that you can leave retirement to charity. And the reason why that's important is because, you know, retirement money gets hit twice in a taxable estate. You're going to be hit on the estate tax side, and you're going to be hit on the income tax side with income tax on the distributions. So charitable remainder trusts, you know, may be attractive to attempt to get a stretch payout that we had under the prior law. Again, I think your facts and circumstances need to be, you need to pay attention to your facts and circumstances before pursuing this. But, you know, one of the techniques floating around is the Testamentary charitable remainder trust. The idea is the retirement's payable to the charitable remainder trust, and the term of the trust is over a beneficiary's life expectancy, or possibly two beneficiaries' life expectancies, or for a term of 20 years. The beneficiaries receiving payments during the term of the trust, you know, will pay income taxes, you know, according to the tier rules. And at the end of the day, upon the beneficiaries, the non-charitable beneficiary's death, the monies flow to the charity. Definitely something to think about for certain types of client situations. And I'll give you an example. I mean, I think a CRT is viable for the adult child who is not formally disabled, but you may have an adult child in need, and you don't necessarily want to give too much outright to the adult child, but the adult child needs a stream of income. There may be some opportunities there with a charitable remainder trust. Again, consultation is critical. All right, next slide. Okay, what are our action steps? Tom and I have talked a lot about the Secure Act and you know, things we need to think about. So what do we do? And I like the way Tom phrases step zero. I mean, you need to know what you have. I mean, everyone on this call ought to know your primary beneficiary of your retirement and your contingent beneficiary of the retirement. Okay. So you'll want to pull and review all your primary and contingent designations for qualified retirement plans and IRAs. Definitely want to review any and all trusts, revocable trusts, special needs trusts, any marital trust out there, any marital trust as a subtrust of a revocable trust, and flag the provisions relating to qualified retirement plans and IRAs. And the hint there is just look for 401A9 and you'll find it. I think the power of attorney is particularly important. You need to read your power of attorney to see if your agent has the ability to change beneficiary designations. Okay. And then also, big picture standpoint, you know, clients with adult children really need to think about, do I want my adult child to have these monies outright, or do I want my adult child to have these monies in trust? Okay. I think order of death scenarios are particularly important in subsequent marriage situations. And I think that creditor protection and income tax consequences need to be weighed against one another when you're dealing with non-disabled, chronically ill adult child beneficiaries. Legal documents likely need to be amended or restated. And of course, as I've said numerous times, I mean, the strategizing, this collaborative team approach is absolutely critical given the income tax and creditor protection sensitivity of these assets. We are out of time. Thank you very much for your participation today. We certainly appreciate it. And please don't hesitate to email Tom and me if you have any follow-up questions. Thank you.
Thank you so much to John and Tom for their presentations today. For those of you in attendance, we appreciate you taking the time to join us and hope you're able to take some of the information you learned and apply it to your own business and clients. Thank you again, and that concludes today's webinar.